By the way, thousands of rape committed every year in India and most of them are strangled unreported, and most of the reported rapes are assassinated because of the socio-judicial conditions. However, amidst all, the 2012 Delhi gang rape incident or Nirbhaya case has shaken the whole country. The incident was in itself of such in nature that raised many questions on law, and it was the reason that after this incident many of the things have been changed, including the amendment in the definition of rape, increasing the quantum of punishment, setting up the fast track courts for such cases, providing special treatment to victims, etc. And like all other cases, this was also forgotten. If we talk about the de facto changes in our society after this incident and the subsequent amendment in the law, in spite of the fact of this that law and punishment made more severe and stringent, the incident of the rape rate didn't decrease. Anyway, our topic here not to discuss the rape rate in India and other such rape incidents, but rather I am intended to discuss law of capital punishment and associated morality, especially in such cases where majority of the people attached emotionally. Besides, in the present case, the question is raised because of some legal lacuna. The repeated postponement of the death execution of all 4 convicts again pulled the public's attention. However, before coming to the topic that I am intended to discuss in this video, let's have first the fast recap of Delhi gang rape. It is the incident of December 16, 2012, somewhere in Munirika, located in South Delhi. The incident took place with a 23-year-old female physiotherapy intern who was brutally beaten, gang raped and tortured in a moving private bus, in which she was travelling with her male friend. In bus, there were 6 other people, including the driver. All of them raped the girl and beaten her friend, and in a chilled winter night, thrown away in an open space to die. Since the Indian law doesn't allow to publish the name of any such victim, therefore the victim was widely known as Nirbhaya, which means fearless, and her struggle and death became symbol of women's resistance to rape around the world. Subsequently, all the 6 accused arrested and charged with sexual assault and murder. Among 6, one of the accused, namely Ram Singh, died in police custody from possible suicide on March 11, 2013 in the Tihar jail. The rest of the accused went on trial in a fast track court. As a result of this, one of the accused, who was juvenile, convicted of rape and murder and given the maximum sentence of 3 years imprisonment in a reform facility as per the Juvenile Justice Act 2000. On September 10, 2013, the remaining 4 adult defendants were found guilty of rape and murder and hence were sentenced to death by hanging. Further, on March 13, 2014, Delhi High Court upheld the guilty verdict and the death sentences. And since that time, on appeal in higher courts, finally on December 18, 2019, the Supreme Court rejected the final appeals of the condemned perpetrators of the attack. As a result of this, on January 7, 2020, judge issued the death warrants for all 4 men, scheduling their execution on January 22, 2020 at 7 a.m. in Tihar jail, Delhi. However, one of the accused, Mukesh, filed a mercy plea to the president. But the President of India rejected the mercy plea of the convict Mukesh Singh. But because of his such mercy plea, not only his but rather all 4 convicts' death execution postponed. In fact, as per the prison rules, if a case has more than 1 convicts awaiting death penalty and one of them moves a mercy plea, then the execution of all the convicts would need to be postponed till a decision is made on the pending mercy plea. However, as the President rejected the plea, the Delhi court issued second death warrant for the conviction after a 14 days gap on February 1, 2020 at 6 am. The 14 days reprieve was provided in accordance with the law, which states that the convicts awaiting an execution must have a reprieve after their mercy plea is rejected. But again, because of another mercy plea by another convict, again death execution postponed. But again mercy petition was rejected, and on February 17, 2020, Delhi court issued the third death warrant to execute on March 3, 2020 at 6 am. But once again, taking advantage of lacuna of legal provision, the death warrant is postponed. However, March 4, 2020, the fourth death warrant issued by the court and the execution date is given March 20, 2020 at 5:30 am. Now, the question is there any chance of fourth time postponement of death warrant? In order to answer this, let's understand the legal provision and proceeding of death warrant execution. Once the trial court awarded capital punishment to the convict, it has to be confirmed by the respective high court. If high court confirms, then the death capital is confirmed to be executed. However, the convict has the right to appeal in the Supreme Court within 30 days from the date of confirmation by the high court. Once the Supreme Court confirms the death sentence, then convict has the right to file review petition in the Supreme Court itself within 30 days from the date of the order by the Supreme Court. Once the Supreme Court rejected the review petition and confirms the death sentence, then convict has another right to file a curative petition in the Supreme Court itself within 30 days of date of the rejection of the review petition. And finally, after the rejection of curative petition, the convict has the only remedy left with him or her is to file mercy petition to the President within 30 days of the date of rejection of curative petition. And if even President rejects the mercy petition, then the convict left with no option or no lifeline. So, after going through all these provisions, all the four convicts have lost their all lifelines. In normal circumstances, there is no hope for the further postponement of the death warrant. However, further it seems impossible, but in rare circumstance it may be. Now, the most important question of this video is that I am intended to discuss about, that is law versus morality. Which one should supersede, especially in such type of heinous crime cases? Let's start with the legality question. Whatever the defense lawyer is doing, that is the part of his profession and it is permitted within the basis of law. There is no question on his act. Even asking questions like what you would have done if the victim would be your daughter, sister, I personally believe is irrelevant and even offensive question for anybody. Because in Hindu Dharma, doing duty prima facie is placed at the highest order. Now, let's discuss the morality of the case. By observing many of the judgments, including the adultery law case, cases related to religious matters, cases related to right to speech and expression, etc., it can be said that morality has hardly anything to do with the legality of an issue. Both are separate entity and no more looked as supplementary and complementary of each other, as earlier used to be. Or in other words, law is completely uninfluenced by the question of morality. And the case that we are discussing here is the perfect example of this statement on the part of the defense lawyer exclusively. Now, you might have the question, how? We have discussed above that on the legal point of view, the defense lawyer is doing his duty within the permitted periphery of law. But if we talk about the morality or moral ground, no advocate is supposed to even accept such type of cases at all. Maybe for an advocate it sounds rude. Don't take it an offense. Just imagine once the same thing happened with someone who is your own. Though I avoided this question to asking anyone in my first part, that is legality question part. But again, in morality part, I am asking this question. So, simple imagination of such type is strong enough to shake your whole body and mind. Now, imagine with whom it happened. Duty, of course, is priority, but duty is not summum bonum of mundane life, and it cannot be. A sensible person, based on given condition, behaves in such a way that best fit into that particular situation. If it is morally good, even though it is illegal, he does so. You may find dozens of such examples in our scriptures as well. For example, in Mahabharata war, the assassination of Bhishma, the assassination of Dronacharya, the assassination of Karna, Duryodhan, Jayadratha, etc. all were illegal. But to protect the interests of society at large, all such assassinations were committed under the guidance of Lord Krishna, and hence it is well justified. There are a number of such examples where in such sensitive matters, like in our present case, morality overshadows legality. Therefore, I leave this topic without conclusion and ask you to analyze and share your views in the comment box given below. See you in next video.